Were you involved in a Virginia car accident case and the defendant, the person that caused your accident, that caused your injuries, was either given a traffic ticket or a criminal charge for the behavior that caused the accident? And you're wondering, hey, James, can I use this traffic ticket or criminal charge to establish fault in my car accident case? Watch this video and we'll tell you what we think. Hey folks, James Abrinio coming to you from Abrinio Law, your Northern Virginia personal injury and criminal defense law firm. First of all, before we start, up on the screen is our website, our phone number, and my email address, and also our social media handles. So make sure to reach out to us if you have questions about Virginia personal injury or criminal defense law. You can also make sure to subscribe to our YouTube channel. We're making an effort to try to get a bigger audience so we can have a bigger impact. And we're constantly updating our channel with information and answering your questions. So make sure to subscribe. So in this video, we're going to answer, when can a defendant's traffic ticket be used in your Virginia car accident case? So we're talking about scenarios where you're driving down the road, for instance, you go through an intersection with a green light, defendant runs the red light, causes a T-bone accident, causes severe injury to you, and they've been charged with either a traffic citation, let's say running a red light, or reckless driving, a criminal charge. And you're wondering, can you use that ticket in order to establish liability in your case? Now, first of all, before we begin, why does it matter? Well, under Virginia law, Virginia applies something called contributory negligence. We're one of 3 states, I think, that apply this rule, but one of the vast minority of states that apply this rule. That rule essentially says that if the defendant, the person that caused your accident, is 99% at fault and you're just 1% at fault, you lose. You're barred for recovery. Essentially, if you've contributed at all to your accident, that's an absolute defense to the defendant having to pay for your bills, having to pay for your lost wages, and the like. So establishing fault early on, it's super important when it comes to a car accident case, when making sure that we can try to get you compensated for the injuries that you sustained as a result of the accident. So how do we determine this in Virginia? And when we're looking at fault, using the defendant's charge against them, using the fact that they were charged against them, can be super useful. So how can we use this? We look to Virginia Code 8.01-418. And what I'm going to do is go ahead and share the screen here. And then we're going to actually look at the statute really quick. So now I've pulled up Virginia Code section 8.01-418. When pleas of guilty or nolo contendere or forfeiture in criminal prosecution or traffic case admissible in a civil action. So what this statute says, whenever in any civil action, which your personal injury case would be a civil action, it is contended that any party thereto pled guilty or nolo contendere or suffered a forfeiture in prosecution for any criminal or traffic infraction which arose out of the same occurrence which the civil action is based, evidence of said plea or forfeiture is shown by the records shall be admissible. And so what that means is when the defendant pleads guilty or nolo contendere, without a doubt, that plea will be able to be used in your personal injury case to help establish liability, to establish that the defendant was at fault for this accident. Now, the big question I often get is, well, okay, if they pled guilty, I understand. If they pled nolo contendere, which nolo contendere is essentially you're not affirmatively pleading guilt, but what you're saying is I recognize that the facts are sufficient to find me guilty if I were to go to trial. The one question I get is, what does it mean to suffer a forfeiture in a prosecution? And oftentimes the scenario comes up where a defendant is charged with reckless driving or improper driving, whatever the case may be, and they simply don't go to court. And does that mean that they suffered a forfeiture in a prosecution? Which, honestly, in my read, it would seem to me that the answer would be yes. However, because the statute isn't clear, it doesn't clearly define this, the way that we attorneys determine what these words mean is we look to case law. So I've actually looked up the case. It is Yeager versus Adkins, 250 Virginia 1. This is a citation, 1995, and this is coming from the Virginia Supreme Court. Essentially, this is our highest appellate court that helps define statutes. And what that synopsis of this case essentially says, plaintiff in a personal injury action arising out of a motor vehicle accident appealed from a judgment entered in the circuit court. The Supreme Court held that the defendant's mere failure to appear in general district court to contest a reckless driving charge and subsequent payment of fine did not constitute a forfeiture such that evidence of reckless was admissible. What this case is saying is that the fact that a defendant doesn't show up for their traffic charge is not enough under this statute, under 8.01-418, to then be used in your personal injury case. So the fact that the person just didn't show up, that now can't be used for us to establish fault. Now, in its analysis, usually you're going to see several pages of the court interpreting what these words mean. Unfortunately, this opinion is only 1 page long, and there's not really much analysis. It essentially just said, we don't find that it fits the statute. I find that a bit disappointing. I disagree with it, honestly, but I'm not a Supreme Court judge or justice, so I don't get to make the rules until this case is overturned. That is the rules. So just want you to be clear. Unfortunately, if the defendant fails to appear, that's not going to be able to be used in your personal injury case. So now the next question is, and I'm posing for you, is why don't convictions count? Let's say a scenario where a defendant does show up, they plead not guilty, and a court finds them guilty. Unfortunately, under Virginia law, that finding is not admissible in your personal injury case. It's not going to be able to be used. I can't go to a defense attorney or to a judge and say, or to a jury and say, look, this person was convicted of reckless driving in the criminal traffic court. That's admissible in our personal injury case. That should show or establish liability. Now, why isn't that being able to be used? The reality is that is actually technically a hearsay finding by a judge that's litigating a matter that's not between the same parties. So in a traffic or criminal case, the parties are actually the defendant versus the Commonwealth of Virginia, the community itself, not just you, the individual. In your personal injury case, you're going against that defendant directly. In a traffic or criminal case, it's the community versus that defendant. And so when a judge makes a separate finding of guilt, despite the defendant saying, I'm not guilty, that's not usable in our traffic case. And it makes sense. The issues are somewhat different. Whether or not somebody was reckless driving has to meet a very specific statutory requirement. It also doesn't establish fault. Somebody can be recklessly driving and not be solely at fault. There could still be contributory negligence on behalf of a plaintiff. So it just doesn't, unfortunately, come in. And it does raise an important point that even if you win the traffic case, the criminal case, even if they plead guilty, that doesn't automatically mean you win, because there's still an argument that you're contributory negligent if that indeed the facts bear out there. How about this question? Even if you can't use the outcome, even if you can't say, hey, the judge found guilty, can you bring the fact that the person was charged itself? That, again, is not admissible unless you can tie it in my view, under 8.01-418. Charge itself is not really relevant. That's one officer's determination of what they think is fault, and their conclusion as to who's at fault for the accident is simply not admissible. So yes, you can't use that there were charged. Only if they've pled guilty to that charge or pled nolo contendere can you use that. Now, the other question I get a lot is, well, what is a forfeiture of a prosecution? And the only thing I can think about in my mind right now is when somebody takes what we call a deferred finding, which is essentially a form of nolo contendere or a guilty plea where the case is being deferred for a period of time and then dismissed later on. But I really can't think of any other scenario. And yes, it seems weird. And this video may be disappointing to folks that have situations where the defendant is charged, but either they were not made aware that the charge was dropped, or they weren't brought in to help the prosecution, and the defendant ended up getting the case dropped, or they went to trial and the defendant was found not guilty, they were found guilty, even that can't be used. So in a weird way, at least for civil purposes, if you're hoping something happens, I'd rather, for instance, somebody charged with a criminal reckless driving, I'd rather them plead guilty to an improper driving, and that finding can come in to our personal injury case as a personal injury attorney, rather than if they went to get trial on a reckless driving and were convicted. For our purposes, for me trying to get money for you to compensate for your injuries, I'd rather us establish liability rather than that person getting a criminal conviction and even jail time. Now, obviously, your priorities may be different and all that, but as a personal injury attorney, on my personal injury attorney hat is on, I'm thinking about what is the easiest way to establish that you are not at fault for the case at all. And using the defendant's charge, using their plea helps a lot. Now, again, I just want to caveat that it is still possible to be found contributory negligent, even if the defendant is found to be in violation of the traffic law or criminal laws. Let's say a scenario where the defendant ran a red light, but you were also speeding, and you were texting and you weren't looking, and you made no effort to try to avoid it, and there was an opportunity to avoid it. It's still possible that you could be contributory negligent, but using the defendant's traffic or criminal citation can be leaps to establishing fault. So hopefully you found this video useful. What I would also recommend, I would recommend that you go to our website, which I'm going to go ahead and pull up here. If you go to our website, on the first page, you get to see my fancy face, but more importantly, you can go to practice areas where we've shot in a bunch of videos, done a lot of articles about personal injury law, about other areas of law. If you've been charged with crime, we've also got a criminal defense page, but I recommend you go there. If you go to, for instance, the car accident page, you scroll down, there's a bunch of questions we've already answered. Should you sign a HIPAA release? What's the statute of limitations of your case? We're talking about contributory negligence in this argument. Should you use your health insurance to pay your bills? We've also down here answered a bunch of other more detailed in the weed questions. So if you're somebody that likes to learn, likes to educate yourself, I would highly recommend it. If you have other questions, make sure to reach out, and hopefully you found. So we wish you the best. Take care.